Welcome back to another J. Harris Academy Police Training Roll Call. Today we're going to be discussing the state of New Jersey versus Victor Rosario. This is an unpublished Superior Court appellate decision that was just decided on October 16th, 2023. The state is appealing the Law Division's order granting the defendant's motion to suppress the warrantless seizure of physical evidence from his person after he and several other individuals were detained while the police executed a search warrant at the home of the defendant's neighbor. No officer testified at this hearing. The court only relied on the transcript of the telephonic search warrant request, 2 body camera videos, and the incident report, which were the only items entered into evidence at the suppression hearing. On June 24, 2022, the detectives executed the search warrant. The purpose of the search warrant was to receive a large recovery of illegal firearms that were being brought to the defendant's home. Based on the detective's testimony, the judge found probable cause and issued a search warrant that was limited to the premise of 109 Howard Street, including the detached garage and Lima Pineda's person, to search for the weapons delivered to the premise. According to the incident report, at 12:33 a.m., members of the Special Operations Response Team arrived at the scene. The Special Operations Response Team body cam video showed officers shouted hands up at the individuals that were on the porch and on the ground to the defendant who was standing between the fence and the chain-link fence. The defendant immediately complied by laying down on the ground with his hands behind his back. An officer then turned around with his back to the defendant, entered the house to execute the search warrant. He instructed another officer who was outside the chain-link fence to keep defendant on the ground. Defendant was not frisked by any of the SORT officers. A second body camera video shows the defendant was left unattended, still laying in the same prone position while officers questioned Lima Pineda and 2 other men in front of the yard. It was only then, when an unknown officer directed the detective's attention to defendant, that he finally approached him. Detective rolled defendant over and ordered him to stand up, which he did. The detective then patted defendant down without asking any questions and found a gun in defendant's left front pocket. Neither video depicted any threatening movements or gestures that would raise suspicion that defendant was armed or dangerous. In the state of New Jersey versus Victor Rosario, they bring up a case from the United States Supreme Court, Ibarra versus Illinois. In Ibarra versus Illinois, there was a search warrant being executed on a tavern that Ibarra had no actual affiliation with. He was merely a patron of that establishment. In that fact pattern, they said the initial frisk of Ibarra was simply not supported by a reasonable belief that he was armed and presently dangerous, a belief which this court has invariably held must form the predicate to a pat-down of persons for weapons. We need to have reasonable articulable suspicion that people are armed and dangerous for us to do a pat-down for weapons. When the police entered the Aurora Tap and Tavern on March 1st, 1976, the lighting was sufficient for them to observe the customers. Upon seeing Ibarra, they neither recognized him as a person with a criminal history nor had any particular reason to believe that he might be inclined to assault them. His hands were empty, he gave no indication of possessing a weapon, he made no gestures or other actions that are indicative of intent to commit an assault, and he acted generally in a manner that was not threatening. At the suppression hearing, the most that Agent Johnson could point to was that Ibarra was wearing a 3/4 length lumber jacket, which they admitted would be expected as any tavern patron in Illinois would wear in early March. The state was unable to articulate any specific fact that would have justified a police officer at the scene in even suspecting that he was armed and dangerous. In this particular case, they discovered CDS, which was ultimately suppressed. So as I read this case, I pointed to a couple of cases that we discuss in our classes that we teach at J. Harris Academy of Police Training. One of the things that we always bring up is what is the actual justification for detaining occupants while executing a search warrant? There's a legitimate law enforcement interest in preventing flight in the event that incriminating evidence is found, the interest in minimizing the risk of harm to the officers, and the orderly completion of the search, which may be facilitated if the occupants of the premise are present. A case that we discuss and that has similar fact pattern to what we see in Rosario is Bailey versus United States. Preparing to execute a search warrant to search a basement apartment for a handgun, detectives conducting surveillance in an unmarked car outside of the apartment saw 2 men, Bailey and Middleton, leave the gated area above the apartment, get in a car, and drive away. These detectives waited for the men to leave and then followed the car approximately a mile before stopping it. They found keys during a pat-down search of Bailey, and after arresting the men, they discovered that one of Bailey's keys unlocked the apartment's door. Was this permitted? No. Here they pointed to the Summers Rule. the rule in Summers is limited to the immediate vicinity of the premise to be searched and does not apply here, where Bailey was detained at a point beyond any reasonable understanding of the immediate vicinity of the premise in question. Again, looking at the Summers rule, what are we looking for? Officer safety, facilitating completion of the search warrant, and preventing flight. Next case I'm going to discuss is State of New Jersey versus Carlino. My favorite part about this case is that Carlino walked past an officer who was searching a vehicle inside of that driveway and walked into the home as the officers were conducting that search warrant. Imagine being the officer and turning around, and there you see somebody who you don't recognize, who now is clenching a fanny pack in his hand. As he walks in, he becomes physically nervous, clenches that fanny pack harder. In this search warrant, one of the things that was listed is the authorized search of any and all persons arriving at, departing from, and located therein reasonably believed to be associated with the investigation. So already substantially different than what we had with the Rosario warrant. And here, he had the fanny bag, he became nervous, he clutched it in his hand harder, and then the officers did a search where they found 100 ecstasy pills. The question here was that search permitted? And I think you could see absolutely. Number one, it already said inside of that search warrant that any and all persons arriving at, departing from, and located therein are subject to the search. He was physically nervous. He's clenching a fanny pack, which obviously we can articulate could potentially contain a weapon. And here it was actually admitted. The next case that we discuss in our class is New Jersey versus Bivens. Here, when you look at the language in the warrant, the language is very similar to Carlino. The troopers were executing a search warrant on a 24/7 drug house. That search warrant permitted search of all persons present, reasonably believed to be connected to said property and investigation. The trooper saw the defendant leaving that house, relayed that information to a separate trooper, who ultimately pulled that vehicle over. The trooper that pulled that vehicle over did not personally see them leaving that house. The vehicle was on the same block as the target residence on the same side of the street. As the trooper approached the gray Pontiac, he saw two individuals seated in the car that were later identified as Chad Bivens and his cousin. That trooper did not personally see Bivens or his cousin leave that actual residence. The trooper and his partner removed the men from the vehicle, searched them, and found 35 bags of cocaine on each of them. Here, that evidence was suppressed. Because the state did not provide adequate proof that the individuals found in the car had been present at the targeted residence when the warrant was being executed moment before the apprehension, the warrant did not provide proper authority for the search of the two off-premise individuals. Here, it could have been different if that trooper that actually observed them leaving the house had one continuous event where he did that stop. But because it was a separate trooper who did not personally see them leave the house, that search was suppressed. Let's compare the fact pattern of Bivens to New Jersey versus Watts. Here you'll see a very substantial difference. Officers have a search warrant and wait for the defendant to leave his apartment. He's seen leaving his apartment, walks to a liquor store a couple of blocks away. Officers detain him as he leaves. They pat him down briefly for weapons. They say that they didn't do a more intrusive search because of how busy of a street that it was. They transport him in the vehicle back to his home, and as he gets out, he shakes his leg. 4 bundles of heroin fall out. 6 minutes had elapsed from the moment of his detention to the discovery of the drugs. Here, Watts made a motion to suppress the drugs, claiming that the police were forbidden from detaining him to conduct a second search of his person after the pat-down on the street. Here, the evidence was admitted. Because the police did not act in an objectively unreasonable manner in violation of the federal and state constitutions by conducting an initial pat-down of Watts and detaining him for a thorough search in a more controlled, safe, and secure location. Again, this is Joey Sperlazza with the J. Harris Academy of Police Training. I hope you found this roll call training helpful. Please follow us on Facebook, Instagram, and YouTube. Check out our podcast, LEO Radio, where we not only discuss case law, but other relevant topics in law enforcement. If you're interested in taking one of our case law classes, please see our website, where we have a full course catalog where we can help bring you to the next level in your career. Stay safe.